the real insurance arguments in the Wayfair case. I found them. They're in one of the attachments, and it's this letter from the Wayfair's coverage counsel to Harco, the insurance company's counsel. I'll admit I was a bit thrown off. Evan Shapiro is actually a woman, so when it said Miss Shapiro, I was like, oh, did they make a typo? No, they did not. Anyway, this letter is from July. So, the Wayfair teams received a denial, and they're writing back to Harco and their lawyers, being like, your denial is a bunch of BS, is what they're trying to say here. And we get to see what their logical reasoning is here, and I'm starting to like their arguments a little bit more. I was at first concerned about the warranty statement, but since we found out new things in discovery, it does not look like HR had a formal complaint in spring of 2023, at least from what we've seen that's come out to the public from what they've discovered. I'm not seeing that. So we're already getting potentially past that hurdle. Now, Harco has harped on the November 2023 letter, the 17-point list, 30-point list, whatever freaking number of points, saying that that was a claim. And because it was a claim, it needed to be reported then. Now, under the definition in the policy, I would say, yeah, potentially that was a claim because it's a written demand for, I think the way it's defined is monetary or non-monetary relief, injunctive relief, reinstatement, re-engagement, reemployment. I believe I've just cited the definition from my head. To me, it looks like a written demand for non-monetary or injunctive relief, maybe one of the re's as well. So you're kind of in claims land. But policies also have something about interrelated claims. So interrelated claims will all relate back to the date of the first claim that it's interrelated to. And so what I can kind of tell, and I haven't read this fully, but I can already kind of tell where they're going with this, is they're saying, sure, there may be an overlap in facts for this letter, but this does not necessarily mean that they are related claims. And courts have repeatedly recognized that just because there's an overlap in facts, in some facts, does not make the claims related, interrelated, or the same claim. And so now I think about the smear campaign and how that ties into the retaliation, right? Well, that could not have been part of that November 2023 letter because the smear campaign allegedly didn't start until way later. And these are duty to defend policies, and as they state here, a duty to defend arises whenever the allegations in the complaint fall within the risk covered by the policy. Retaliation is pretty cut and dry for an EPL policy. If it's related to employment practices, that's covered. Obviously, there's some exclusions, but you get what I'm saying. This continues. It therefore includes the defense of those actions in which alternative grounds are asserted, even if some are without the protection purchased. So I'm starting to think a lot of this is going to come down to if these claims are considered related. They talk about a case law example, and they say that the Delaware Superior Court concluded that in a 2019 securities class action, challenging the fairness of shareholder compensation in a merger was not interrelated with 4 2016 lawsuits alleging acts that improperly led to a merger. The court applied the meaningful linkage test, and it stated that the primary factor which determines whether two claims are meaningfully linked is if they involved the same conduct. And here they go. They go, this is particularly evidenced by the fact that the alleged conduct that forms the basis of the retaliation, false light, invasion of privacy, and defamation claims asserted in the lawsuit did not even exist at the time of November 2023. It was like I read their mind. Then they talk about late notice because, as Harco said, the lawsuits were initiated, end of December? They weren't notified till end of April, so they had, 4 months of litigation. And so in this letter, it says, the policy states that the insurer may assert that a notice of a claim is not as soon as practicable only if the insurer has been materially prejudiced by such late notice. So that requires the insurer to prove that the insured's late notice of a claim has substantially prejudiced its ability to investigate and negotiate payment for the insured's claim. They say, Harco has not established this. What's interesting, so I kind of just skimmed the rest of this letter and maybe go through it again. I want to see the denial letter. I don't think I've seen that. Because they threw in a bunch of other exclusions, which I feel like they were just trying to throw in. So we'll see. This was well written. I see who this was CC'd to. It was CC'd to Mitra as well, from the McGuire Woods attorneys. So let me know if you have any questions.